Hello everyone, this is Camila Mota. I am an associate lawyer at AP Lawyers in Pickering. We have a great team of lawyers with us, family law lawyers, immigration lawyers, and we have a great supportive admin staff, and we are always very happy to help you. So this webinar, we usually have frequently, we have webinars maybe every other week about several issues. This one we found it to be very interesting because we are in the middle of the pandemic in August. Today is July 20, 2021. In the end of August, most school boards in the province will give the parents the last opportunity to decide if their children are going to attend school in person or if they are going to continue with online learning. As we know, it is a very difficult decision to make. And when parents are together, they have the advantage of being able to talk and decide together. When parents are separated, then this is one more piece in that big puzzle that comes with separation. So Chase and Chase was a decision in the Ontario Superior Court that was made in August 2020, and it was the first decision about this case when one parent wants to the child to go back to school and the other parent wants to keep the child home. So what the judge, usually judges are not too happy when parents cannot come to the negotiation table, when they cannot really have a conversation, especially when it's about the kids. So in Chase and Chase, the judge said that school attendance in the midst of a pandemic is a challenging issue for many parents. Unfortunately, for some separated and divorced parents, this is another battleground, one more arena where their child may become the prisoners of a war. So what we are trying to attempt with this webinar, what I am trying to attempt, is to help all of you who are watching this to maybe look over at the other cases and all the cases that the courts here in Ontario have decided about this issue. And maybe with this information and being better informed, you can talk with your co-parents and you can reach an agreement that is best for your family. So in Zinati and Spence, which I believe was maybe the second decision on the same issue, also from 2020, the judge reminded us that we are not safe in a pandemic. We cannot guarantee safety from this virus. We can mitigate the risks and we can consider who is at a higher risk, like what we can do to deal with a specific case. But generally, the pandemic is only over for those who did not survive it. So basically what this judge was trying to tell us is, okay, like one parent, the parent that wants to keep the kids home, they need to realize that this is not going to completely put the child in a bubble and protect them, because there are other factors. There are other people living in that house. Even the child needs to go out, they need socialization, they need to go to doctors, they need to go on with life. And the pandemic is pretty much out there. Now, July 2021, the vaccines are giving us some hope, especially here in Ontario. It's going really well. So we hope to get to the end of this tunnel soon, but we are still not completely safe. Even staying home or going back to school, both situations do pose some risks. So what the court in Chase and Chase suggested, and what we as lawyers, we have a duty to recommend to our clients, is to always try alternative dispute resolution. So try mediation, try talking, negotiating between lawyers, try talking to a friend may mediate. So what the court here said is going to court is delegating the authority to make the decision respecting the child's in-person versus online attendance at school to me, a judge who has never met the parent and who will likely never meet the child. I would encourage the parents to return to mediation, as this is a process that empowers them to make these important decisions. So basically that's it. When we go to court, and not only about this issue, when we go to court, we are delegating a decision that, like, primarily we should be the ones making. We, like, when I'm talking about we, I'm talking about us parents. We have the responsibility to make this decision, but because we cannot agree with each other, we delegate this decision to a court. And the judge will have to follow public guidelines, will have to follow common sense, and the judge doesn't really know your family. The judge doesn't really know, may not really know what is specifically best for your child. So the judge suggests, in that case, Chase and Chase, a better approach is to engage in mediation with a professional or a third-party trusted family member or friend. There are court-connected mediation services that are readily available here in Ontario. It is a subsidized or free service available to help parties achieve agreements. I had the opportunity to check their availability for some of my files before, and they were readily available. The prices are either free, it depends on your income, so each party will pay for the mediation based on their own income. So it's not, of course there will be some costs, but it's not going to be, not even close as going to litigation and the motion and all the court proceedings. So in this case, in Chase and Chase, again, the mother started with the application in the beginning of August, I believe, of last year. And then it was urgent because the children would have to start school in September. So what the court was not happy about it, obviously, and the judge wrote that this is a self-fulfilling prophecy because the parties do not act, they do not pursue mediation, they wait until classes are about to start to commence an application. And then we are right there. The task for urgency is met because the child has a right to know the plan for the upcoming school year, and the parents need time to prepare for it. So even if the court is not happy about it, the urgency is clear, and they need to assess it even before the usual process. That would be go first to a case conference where the parties have the first opportunity to settle the case or to settle some of the issues, and then they may bring a motion. So in this case, most likely we are looking at an urgent motion, and the judge in Chase and Chase also said that because the courts are so swamped, especially before September, these motions will most likely proceed in chambers on the written evidentiary record. So that means you won't even have a hearing, so you won't even meet with a judge, not even online. So it will be just on paper. That's not necessarily true for all the cases, but in Chase and Chase, that was the judge's position. That one was in writing, and they believe that this would be the situation for most of these urgent motions. In McKee and Bellinger, also from 2020, the case was brought. It was an urgent motion too, and the classes were already taking place. So obviously the urgency test was met, and the judge said that it is imperative that the boys commence either online or in class learning at the beginning of the school year. Classes have already begun. So, and we want to avoid that. So the first question is, who makes the decision? So if there is one parent that has a court order, or because of an agreement, a parenting agreement or a separation agreement, if this parent has sole decision-making authority, which before we used to call sole custody, generally the court will not interfere with their decision because they believe that this parent knows the child best, they can meet their needs best, they understand what this child needs, if there is anything special about this child. So unless it's clear, it becomes clear to the court that this parent is not really taking into consideration the child's needs, if the parent is being unreasonable, the court will not change the parent's decision. However, in most of the cases I reviewed, and most of the cases that come before the court, the parents have shared decision-making authority, so they both have equal decision-making power, or there is no agreement or court order in place yet. So the court has to make the decision, and the court will consider many factors to determine what is best for the child. So what are the relevant factors? In Zenati and Spence, the court was very helpful in actually listing some specific factors to be considered when considering the two models during the pandemic. So the first one would be the child's risk of exposure to COVID in both models. So as I already said, and like as we know, the child staying home doesn't mean that the child is going to be in a bubble and absolutely safe from COVID. There will still be some risks. So is there someone in the household who is working outside? Is there a healthcare worker or someone who works at a grocery store? So is this child also exposed and considerably exposed even if they're learning from home? So does it make sense to keep this child home? And going to school, is the risk to this child going to increase considerably, because we know that schools need to follow public health guidelines, all the safety that the schools need to follow. So the factor number 2 is a person's increased risk if contracting COVID-19. So is anyone at a higher risk? And this anyone could be the child themselves, or it could be someone the child lives with, the child has frequent contact with. So the court will also consider that. The third factor is the child's adjustment to learning online. So, and to that we need to consider mental health, social and academic development. So we know that like the common sense and generally going to school is best for a child, because they are going to develop not only academically but socially. Their mental health is going to be supported generally. So without special circumstances, it's best for a child to go to school. In this case, if there is something that tells us that the child should learn from home, how is this going to affect the child? Like the mental health. Is the child doing well at home? Is the child feeling too isolated? Is the child still socializing? Is the child struggling to learn? So all this, and this is going to be different from child to child, but we need to consider. Factor 4 is the plans to mitigate all the issues above. So if I am parent A and I want my child to stay home and continue to learn online, how am I going to mitigate all the risks? So am I really protecting my child from COVID exposure? Is my child doing well in school? Like, or are they not really attending school? Are they not really completing homework? Am I creating opportunities for my child to socialize? And these kids with my children are meeting, like, are they attending school? So maybe, anyway, so we need to consider all this risk, and I'm going to talk about these factors later on. Factor number 5, the child's wishes, if it's possible to ascertain. So this is almost always one of the possible factors for the court to consider, but not necessarily one that will take preference over the others. It's usually really hard for the court to ascertain what a child wants. The child can be influenced, and in this case specifically, a child not really wanting to go to school doesn't really mean necessarily that is best for the child. So there is a few things we need to take into consideration. So number 6 is the parents' ability to support online learning considering their competing demands. So both parents need to be able to support the model that the child is going to be following. And factor 6 would mostly apply to a child learning from home. So parent A and parent B, especially when we are talking about a shared parenting arrangement, both parents need to be able and available to support the child's learning, and they need to be able to have the same kind of routine so the child can follow and of course thrive academically. So factor number 1 is the child's risk of exposure to COVID-19 in both models. In Sedation Spence, there was one of the factors is that if the child was kept home, the child would still be in contact within the same household with people who were pretty much exposed, even though they were following all the measures, even though they were being careful, they were pretty much out there in the world and being exposed. So does it make sense to keep this child from school if they are going to be exposed anyway? This is about the increased risk if contracting COVID-19. So this wording that the court uses, unacceptable risk of harm, is helpful because then we can understand better, like there is a risk of harm. We are all exposed to this risk, but in a specific case, is this unacceptable or not? So in Joaquin and Joaquin, the stepfather had lung disease and an autoimmune disease that placed him in a very high-risk situation if contracting COVID-19. The mother, who was remarried to this stepfather, presented a doctor's note saying, talking about the increased risk and like he would most likely die from COVID if he were to contract it. They also had a new baby whose immune system, of course, is still developing. So the other side, the father wanted the kids to go to school, and he said, well, even though I worry about the stepfather and the baby, they are not my primary concern. The primary concern here should be the children. But what the court says is that it is in the children's best interest to keep both families whole. So if the stepfather dies, obviously it's not in the children's best interest because the mother will suffer. It is someone that the children have grown to love and that cares for them. So, and there is also the baby brother who, if became sick, the children would also not do well, would also go through suffering. So of course, like preserving the unit, the family unit is very important for the kids. And in that specific case, many of the adults involved in the two households, they were educators, including the mother, the stepfather, the father. The mother actually taught children the same age as her children. So she was on maternity leave, so she was fully capable and available of supporting the children. The children were considered to be strong students. So even though, of course, they would have some challenges from learning from online, it is not something that could not be mitigated, and temporarily they could go through in order to preserve the stepfather and the new baby brother. Just a point, in Newell and Guay, the court made some reference to a history of asthma. I remember in the beginning of the pandemic, many parents being concerned about, oh, but my child had asthma, he's at increased risk. What the judge said is that generally a history of asthma is not a clear factor to determine the child's increased risk. So you actually need evidence supporting the increased risk, and that it is unacceptable to send this child back to school. So in this case, a parent, when a parent was pursuing online learning for a child due to increased risk, the court says that they need strong evidence, and they suggested that all this is needed. One, it's a diagnosis for the vulnerable person, so either the child or the person living with the child. A prognosis in case the person catches COVID-19. So what does it mean? The person is going to have a harder time recovering. Is the person likely to be hospitalized? Is this person likely to die, more likely to die than most people? If there is any treatment, anything that can be done to mitigate these consequences, any precautions that can be done so the child can safely attend school in person. So for example, let's say in the case of the stepfather, is it reasonable to expect that the child can go to school and the stepfather is going to social distance from them? So all this should be considered when we are using the high risk factor in our argument. So the factor 3 is the child's adjustment to learning online. In Chase and Chase, the parents had shared decision-making authority. And so generally it is best for a child to attend school. And if the government opened the schools after listening to public health professionals, they are in a better position to assess the risks than the court. So what the judge says simply is like, if the government opened the schools, they are deemed it to be safe enough for the general public to attend. So as a judge, I don't have the tools. I would need to decide that a school is not generally safe for a child. Is it not expensive? Then that in this case, we can clearly see how specific the situation can get and how sometimes it is really hard to assess what is the right decision to be made. In this case, the father argued that he was at high risk for COVID because he had some preconditions, but he provided weak evidence. So he provided a doctor's note simply saying that caution should be taken when deciding if the child was going to attend school because of the father condition. But the note didn't really explain what was the condition, what did that mean, so how did that play the role with COVID, and what could happen with the father if he was to contract COVID. So the judge decided that the medical note was not particularly helpful. And in that case, maybe in that case, if this was the only factor, maybe the judge would have decided that, okay, in this case, it's best for the child to stay home and protect the child. But in this case, we had one additional factor, is that the child had learning difficulties. They had a special education plan in place that this child going to school would give them much more support than staying home. So this child has a full team at school prepared to support them in their learning, and at home they would not have the same chance. And the first school closure from March 2020 to June 2020 showed that this child specifically was struggling to learn. So in this case, the court concluded saying that it is unfortunate. The father may need to follow social distancing rules to continue the parenting arrangement, and it's inconvenient, but it's something that some of us will have to endure in these circumstances. So the factor 4 is the plans to mitigate the issues above. So all the problems we discussed, how can we mitigate that? So as the judge says in this last decision we just talked about, if the child really needs to attend school because of specific learning challenges, but the father is at an increased risk, then what we need to do is to protect the father. The father needs to protect himself and social distance. Or if it's decided that the child is going to do remote learning, then how can we really mitigate the factors, like some play dates for the socialization part, some extra work, a tutor or something to mitigate the challenges that the child will have to face in each of the models. For factor 5, the child's wishes, if possible to ascertain. So as I said before, sometimes even when the parents do agree, so the father says, okay, so child A wants to go to school, child B doesn't really want to go to school, and the other side also agrees that, yeah, child A wants to go, child B doesn't want to go. It's not necessarily indicative of what is best for the child, especially when we're talking about school. We know that many children will choose to stay home, playing video games, or playing or even doing nothing instead of going to school. And most likely these are the children that really need to be pushed into going to school. and overcome whatever challenges they find there. So the child's wishes are to be considered, but they are not that important in this case, at least not in the cases I reviewed. So the factor 6 is the parent's ability to support online learning considering their competing demands. So if the parent that wants the child to stay home, they need to show that both parents are available and they can support the online learning. So if we have a shared parenting arrangement, I need to show, parent A needs to show that they can support the child and that the other parent can also support, not only regarding their availability, but their skills. So many children in Ontario, they attend French immersion, and it's very common that both parents don't speak French. So is it possible that they are going to really support this child through their learning? Depending on the situation, yes, the child can be a good self-learner. The online classes may be enough for that child, but in many other cases, it's not enough. The child really needs to go to school. They really need the support of a teacher who is there with them throughout the day. They can only raise the hands and have the teacher come to them. So, and one thing is that it's important to consider is the fact that the parent who wants to keep the child home is available and is able to provide support does not justify changing the parenting time schedule. So does not justify changing the parenting arrangement. So both parents need to be able to continue with the parenting arrangement and continue to support the child in a way that meets their needs. So it's not, if parent A is home, is skilled, can help the child, and parent B is working shifts and unavailable and doesn't speak French, for example, parent A cannot say, okay, so the child will spend time with me. Of course, they can agree to do that, but the court, apparently from the cases I read, will not change the parenting arrangement because of that. So since we are talking about the pandemic, some good reminders is generally COVID-19 is not a reason to suspend parenting time schedule. And when I'm talking about parenting time schedule is what we use to say access. Many parents use the word visitation. So it's not a reason to suspend parenting time. Parenting time goes on. And the model of school attendance also, as I just said, is not a reason to change the parenting arrangement. The other situation is homeschooling is different than virtual school. Virtual school, there is a teacher on the other side. The school is providing the curriculum. The school is providing the activities. The teacher is correcting the assignments. There is the asynchronous learning. There is the synchronous learning. So the parent is not responsible for all the material. The parent is responsible for supporting a child. Homeschooling is different. Homeschooling, you want to take the child out of the mainstream school. You want to homeschool your child. You want to create a curriculum for them. You believe it's best for them if they follow your own curriculum. Usually the parents who do homeschooling, they will have groups to support them. They will even arrange some trips with other parents who do homeschooling. So it's a whole different issue. And when it comes to homeschooling, and understand that after this experience with online school, many parents now may feel it's best for their child to remain home, and maybe they're even considering homeschooling. But then we come again to the disagreement, and when parents cannot agree on a model, and in this case, let's say homeschool or regular school, then the cases I read, the court will most likely follow the decision that the parents made when they last agreed. So let's say the parents were together, the child was attending regular school, and then after they separated, the child even maybe continued to attend regular school, but then one parent eventually decided to do homeschool. Most likely, the court will determine that the child should keep going to school. unless there is some compelling factors playing there. So let's say a child is really struggling going to school, there is bullying concerns, um, something that like tells the court that this child is not meant to be in a mainstream school. Like the mainstream is not working for this child. They do need to experiment a different model of education. And if one parent is available, then great, the court may decide to do that. Of course, the parenting seeking to do something like this, it would be helpful to have expert evidence. So a doctor's notes explaining why the regular school is not helping the child, why experimenting with homeschool could help, maybe a psychologist, maybe a psychoeducational assessment would be helpful, a psychiatrist. I don't know about the specific case, but of course, like if you want to change the agreement you had with the co-parent, if you want something different, and there is no material change, like material change meaning something that drastically changed in the child's life, you really need to support yourself with evidence that will really convince the court that a different model is most recommended for the child. And in the cases I read, what happens with when parents cannot agree and the court decides that's best for the child to actually change the model, what the court will do most times is not simply determine, okay, so this child now is going to attend homeschool. What the court does is simply this parent now will have sole decision-making authority. And then with this, the court also stops every future conflict about education, because the child, the parent, one parent will have the final decision for at least education. Just as a side note that I didn't put in the slides, but it may be helpful, there was one case, I believe it was Chase and Chase, where the agreement was very detailed. There was a court order with a very detailed parenting order where the mother had decision-making authority for big health decisions. The father had decision-making authority for religion and some dental decisions that were not day-to-day decisions. And the parents shared decision-making for education. So that ended up in court, and the mother said that I should be the one making these decisions because in a pandemic, school attendance is actually a health decision. And what the court said is, even though it relates to health, it's still an educational decision. It's still about education. So if they're sharing decision-making authority for education, you deciding about health is not necessarily does not necessarily give you final say during the pandemic regarding school attendance. Okay, so thank you very much for listening. For those who joined us today live, thank you very much. I hope this was helpful. If you have specific concerns, if you need a consultation, please go ahead, book a consultation with us. One of our lawyers will be very happy to help you. And we will continue to offer different webinars with different teams. And we always want to support you with the best information possible. Thank you very much, and see you soon again.